Tonight, we're going to talk about powers of attorney. This is just kind of an overview discussion of powers of attorney. We have another presentation for people that are actually acting as an agent under the document, and they want to know how to do their job properly, what kind of records should they be keeping, what kind of issues should they be sensitive to, which, if you're interested after tonight, you're welcome to come back to that one. I forget the exact date that we're doing that, but it'll be in a few months. We usually kind of do one a little closer to late spring, early summer, and then again in the fall on another topic. So for tonight, we're just talking about a general overview of powers of attorney. And there are three types of powers of attorney under Pennsylvania law. There's a financial power of attorney, a medical power of attorney, and a mental health power of attorney. So we're going to talk about not so much the mental health power of attorney. That's a fairly targeted document for people that have and are undergoing mental health treatment and may want to designate an agent to participate in their decision-making process. We're going to focus on the more general financial power of attorney and healthcare power of attorney. So within that, here are our three types. And I'm going to start by who would you name as an agent, and more generally, what is a power of attorney? A power of attorney, very simply, is a legal document that you sign that designates one or more people to act on your behalf. We call the person that you are designating an agent. Most people will say, well, I'm his power of attorney. That's not technically correct. Power of attorney is really the name of the document, not the name of the person acting under it. It's kind of like saying, well, under a will, you have an executor. You wouldn't say, well, I'm the will. You'd say, I'm the executor of the will. And in the context of a power of attorney, I'm the agent. The older term was attorney in fact. But we just decided to call it agent because that's a little more familiar term. Lawyers use enough words that most people don't know. We didn't need to perpetuate the problem. So, in that document, you are designating, could be one person, could be more than one person, could be a series of people to serve in succession, to make various kinds of decisions for you. Very generally, either financial decisions or medical decisions. It's very common to name a spouse as an agent. A lot of people assume that because they're married, their spouse can do all the things that they would want them to do. And, I guess you didn't pay much attention during the last episode of Divorce Court, because spouses have a nasty habit of fighting with each other a lot and doing very mean things to each other. And they do not get, as a matter of right, by virtue of being married, the ability to just make all kinds of decisions. They can make a lot, particularly on the healthcare side of things, but not all. And in the financial side of things, they really can't make any. You can maybe access a joint bank account, but it's because it's a jointly owned account that you can do that, not because of your status as a spouse. Sometimes people will pick adult children to serve as an agent, or more than one of them to serve as co-agents. Sometimes they'll pick, an advisor or a trusted friend of theirs to serve as the agent. It can really be anybody over the age of 18. But, you don't generally want to give someone the power to act on your behalf if you don't have absolute and complete trust in that person. Because by and large, they are going to be able to do anything that you could do. Anything, not just that you normally do, but anything that you could ever possibly do. So it's an incredibly broad power that you are giving to them. What kind of things are we looking for in an agent? Well, we definitely want them to be trustworthy, particularly on the financial side of things. If the agent is not trustworthy, it's just a non-starter at that point. You cannot give this document or the power under the document to someone who cannot handle it responsibly. So you can kind of abandon the idea that I'm going to pick my eldest child. That's how they picked kings in the 1600s. That's not how we pick agents under powers of attorney. There is no status that should come from being the eldest male in the family. The eldest male in the family may be a complete idiot. You don't want to put him in charge of something when you have a perfectly capable younger daughter who could do the job better. I strongly recommend you pick someone who is independently financially secure. You don't pick the person who's constantly coming to you looking for a loan, who's constantly coming to you unable to balance their own checkbook, because the job of managing your money is on an order of difficulty 10 times harder than managing their own money. If you stop and think about how you manage your money, and you stop and think about how your bank manages your money, you'll come to understand a little bit different. I may not know the exact balance in my checkbook as I'm sitting here talking to you, but my bank sure as hell better know. I expect them to know. I expect them not just to know, but to be able to tell me exactly what's been going on in my account. What came in, what went out, when it came in, how much came in. I want a written statement from them every month telling me that. That's because they're acting as a fiduciary handling my funds. They have a duty to keep records and account to me for the deposits that I have made into their bank. An agent under a power of attorney has a very similar fiduciary duty. They have to account to the principal, the person who signed the document, for whatever they've done. And if agents fall down, it's usually on that score. They don't keep very good records. They just go off and do stuff. They pay the electric bill. They pay the cable bill. They didn't keep a copy of the bill. They didn't keep a copy of the check. Maybe they wrote it down in the checkbook register. Maybe they didn't. Not the sign of a good agent. You want someone who's going to understand that they have to keep a good running record of all the things that they're doing. So being organized is an incredibly good quality to have in an agent. More organized than you are. I don't have to balance my checkbook. I don't have to keep track of my expenditures if I don't want to. But if I'm managing your money, I have a legal duty to do that. And if I'm not particularly organized, I'm going to have a real hard time carrying out that responsibility. So, you want someone with sound judgment. If you think about the people in your family, maybe some folks come to mind when you're talking about someone with sound judgment. Maybe some people are coming to mind because they clearly don't have a whole lot of common sense. These are the people that cash in all their money to buy magic beans in the hope of growing a beanstalk. Again, not exactly the right kind of person for this job. They may be incredibly empathetic, incredibly creative, incredibly insightful people with towering intellects. But when they're, the bumbling, absent-minded professor, not exactly the skill set that we're looking for in an agent. And we want them to be smart enough to know what they don't know and willing to learn what they don't know and to ask for help with things that they don't know. They don't have to know everything there is to know about, for example, preparing your income taxes, but they should at least be willing to know that, if Bill can't file his tax return this year, I'm supposed to handle that for him. I guess I better get myself to somebody who knows how to do taxes. And then they can help me to do that. But I just have to make sure it gets done. Not necessarily that I'm the one to actually do it. So as you're thinking about the people that you might want to name as an agent, or if you're thinking about you having been named and they're wondering, well, what's expected of me? That's kind of a checklist of all the things that are expected of you in order to do the job, and that's the kind of thing you want to think about when you're selecting somebody. To spring or not to spring? Very often in powers of attorney, people will want the document to become effective only when they are sick and they can't handle things on their own. And they'll adopt that idea for two reasons, typically. Number one, well, I don't want it to become effective now because they might use the document improperly in ways that I wouldn't want them to use it. And so they are approaching this decision to have it only become effective when they're sick with the misconception that this is going to make them safer. It's going to protect them from being victimized. Well, number one, if you're worried that the person you're giving the document to is going to victimize you, you've already answered the very first question. Don't name them. Secondly, if you really stop and think about it, what have you said? Oh, I'm worried that this person might do something wrong if I gave them the power to handle my affairs. So therefore, I've decided I want them to be able to handle my affairs when I'm at my ultimately weakest, most vulnerable time. So I only get into boxing rings with heavyweight boxers, not when I'm in prime time fighting shape, but when I'm doubled over with the stomach flu. Then, and only then, do I want to go tangle with a boxer. Really? Number one, you shouldn't be getting into boxing rings to fight heavyweight boxers. Number two, because that's the wrong person to spend your time with. They're boxers. They tend to punch you. It's not a very fun experience. But number two, you don't get into the ring to fight a boxer when you're weak and sick. And if you stop and think about it from a practical standpoint, imagine yourself as a teller in a bank. And a person walks in with a power of attorney and it says, Bill Blumer hereby designates a person who's now standing in front of you as his agent to handle all of his financial affairs, including banking transactions. And this power of attorney shall go into effect when Bill Blumer is sick and can't handle his own affairs. Now you as a teller, how on earth do you know if I'm sick or not? You can't possibly know. So you say to yourself, well, I can't help you, and I know that's going to be upsetting, but I can't help you because I don't know if Bill's sick or not. Go to Bill's doctor and get a note from the doctor that says Bill is sick. And if you can bring me a doctor note, maybe two, because I'm feeling extra cautious today, bring me 2 doctor's notes, and I'll believe that Bill is sick. And oftentimes, that's what these springing powers of attorney will say. Well, these are obviously written by people who haven't encountered HIPAA before. Because HIPAA says to the doctors of our country, hey, you can't go around blabbing about people's medical information without their written authorization to do so. And what you're now asking the doctor to do is write a note that discloses things about me and broadcast it to anybody in the world, including some goofy teller at the bank. So it's very tough to get a doctor to sign one of those little notes anymore. So these springing powers of attorney are just a fundamentally stupid idea. And you should almost never, ever have one. If you have a power of attorney now, and it has that provision in it, I strongly encourage you to get a new power of attorney. Because that provision will most likely make the document almost unusable. Because you're going to have a heck of a time proving that you're incapacitated. Okay? So don't do that.